Can you work and travel while the marriage-based green card application is in process? That's what we're talking about on today's episode of Sumner School Family Immigration Basics. So in today's episode, we're talking about the marriage-based green card process for when the foreign national is here in the United States and the couple is filing the I-130 petition and the I-485 application for adjustment of status at the same time. That's also called a one-step. So a lot of times when we're having consultations with couples who are about to start this process, or we're preparing everything for the couple, we want to make sure that they understand that it is possible in some circumstances for the foreign national beneficiary, or the person applying, to be able to work in the United States before they receive their green card and possibly to be able to travel. But as always, it depends. So let's talk about each of these in turn. Working. When we file a marriage-based green card application, we have the option of applying for the work permit. It's also called the employment authorization document, and you have the option of applying for that as well. There is a separate filing fee for that, a USCIS filing fee for that, so you don't have to, but there is the option of submitting that as well. The travel document, this employment authorization document, is known as an interim benefit. That means that it's a benefit that you will have, assuming it's approved, during the interim while the green card is being processed. Once the green card is approved, you would use the green card to be able to work, of course. The processing time right now for this employment authorization document, and this is subject to change, the timelines change a bit over time, of course, but right now it's taking around 6 months from the time you file the application for the green card until the time that it's approved. So again, it could be less time than that, could be more time than that, but that's what we're seeing on average right now. So in general, if you are applying for the marriage-based green card, you have to wait for that employment authorization document to be approved. You have to have that card. It will come as a card. You have to have that card in hand before you are authorized to work in the United States. Before that, generally speaking, you are not authorized to work. And again, it's important that you have that card in hand. It's not enough to have the receipt notice or even the approval notice. You have to have the actual card to be able to show your employer the I-9. Once you receive that, you can work for any employer. It doesn't matter who you're working for, and you can work full-time or part-time. You could have multiple positions in addition. I said it depends, and that is because there are always exceptions, right? So depending on the foreign national spouse's underlying immigration status, you may be able to work even before you receive that work permit. That would be in situations like if the foreign national beneficiary or applicant is in the United States in H-1B status, E3, TN, perhaps they're working on OPT because they're a foreign student, all kinds of situations where a foreign national may already have work authorization, and you can continue using that work authorization even after you submit the marriage-based green card process, or application. So whatever that underlying work authorization is, whether it's an H-1B, a TN, an E3, maybe you're working on a J, all different kinds of options, right? An employment authorization document based on any number of other underlying bases. But you can work until that particular immigration status, whatever it is, whatever that benefit is that you have, until it ends. So in other words, if you have H-1B status and that H-1B is going to end, then let's say in a month, then you can continue working until the end of that H-1B. But then there's a gap between the end of that work authorization and when you receive your work permit, you wouldn't be able to work during that time frame. So it just depends on what your underlying status is. And it may be possible to extend your H-1B or your EAD or whatever it is that you have. But just keep in mind, if you have work authorization now, you absolutely may be able to continue using that even after you have filed the marriage-based green card application. Now let's talk about travel. In addition, just like you can apply for a work permit, you can also apply for a travel document. That's called the advanced parole document. The processing time for this interim benefit is generally longer. Sometimes clients will receive that around the same time as the work permit, but most of the time it takes longer, now closer to 9 to 12 months, although it can take longer than that. It is not at all uncommon for our clients to actually not receive the travel document, for it just to not be approved before the green card is approved. So again, once the green card is approved, you would use that to be able to travel. in and out of the United States. The advanced parole document is only an interim benefit. And like I said, a lot of times it's just not approved before the green card is approved because the processing times are so long. So if in general, if you're filing this marriage-based green card application here in the US, you cannot leave the United States. Of course, there's an exception that we'll talk about, but you cannot leave the United States until you receive that advanced parole document. Again, it's not enough to have it submitted, to have the receipt notice, to have even the approval notice, although sometimes the approval notice is the advanced parole document, so that's confusing. But it's not enough just to have submitted it or to have a receipt notice. It has to be approved, and you have to have the document in hand before you leave the United States. If you leave the United States before you have this advanced parole document approved, with a narrow exception that we'll talk about in a minute, your I-485, your application for the green card, will be deemed abandoned and denied. And I have seen many times clients who try to file this on their own. They don't know that, and they leave the United States thinking that's what they're supposed to do, or that they can do that for whatever reason, and the application is denied, unfortunately. And there's really nothing you can do in that situation. So know that if you are planning on applying for this, you really have to stay in the United States at least until you get that advanced parole. One thing to keep in mind about the advanced parole is it is designed to allow a person to apply for admission to the United States, but it's not guaranteed that you will be readmitted to the United States. So there's always an element of risk if you're traveling on the advanced parole. Make sure that you talk with your immigration attorney before you make travel plans. The exception, as I said, is if an individual is in the United States in H-1B or L status, then there is guidance, USCIS guidance, that says that yes, you can travel as long as you meet certain requirements. And those, we won't get into all of the details there, but basically if you are in valid H-1B or L status, you have a valid visa, and you're traveling and then coming back to return to the same employer, then you can travel using that valid visa. So of course you have to have a valid visa to re-enter the US because you wouldn't yet have the advanced parole document in this situation, but it is possible to do that in that particular situation. Again, if you have questions about that, feel free to contact us or to ask your immigration attorney who's helping you with this process, because there's some ins and outs you want to make sure of. You don't want to make travel plans or leave the US without making sure that you have a solid plan in place. So I hope that this information has been helpful. The short answer is yes, you may be able to work and travel, which is awesome, while your marriage-based green card process is in process. And for the most part, if you already have permission to work, it is like through another visa classification or another employment authorization document based on some other status, you should be able to keep using that, which is also really helpful. I hope this information is helpful. If so, I would love for you to like this video and share it with a family member or friend. Make sure that you are subscribed to this channel so that you don't miss our next video, and turn on those notifications. We would love for you to be able to join us and catch our future videos. My name is Emily Sumner with Sumner Immigration Law, assisting clients around the world and around the United States with employment-based and family-based immigration matters. Until next time.